Okay, you're all starting to come in. That's lovely to see you all. I'm going to have to chat away for a couple of minutes just to get a chance for you all to be able to get yourself comfortable to watch this webinar. We are very lucky. We've got some great speakers I'm going to introduce you to in a minute. It can be a dry subject, so we're all going to try and be a little less than dry and try and give you useful information and do it in a smiley way rather than a lecture. But there is a huge amount to learn from the guest speakers today. So we're really looking forward to getting your questions as well at the end. I'll cover how we're going to do that. And as soon as we get to a few more, we will begin. So once again, thank you for joining these webinars. We're very pleased to be able to hold them. It's a very cost-efficient way for us all to get this information. Once upon a time, you'd have to go to one of the sort of short-term let shows in London and sit in a noisy exhibition hall trying to hear what was going on. And I can tell you from Ross, Beth, Kurt, myself, having as many people as we've got on this webinar would have been amazing if we could have got those at those shows. So we're very pleased to have you all. Okay, right, we are now going to start. If people come in late, then we can catch up with them afterwards, perhaps. Right, so first slide, please, Dalan. Okay, so this is being recorded. We always record these so that people who aren't able to make them today can watch them at a later date. Questions, that's what the Q&A is for. So just pop your questions in the Q&A and we will get to those at the end of the presentations and try and answer them for you. This is the first of the summer PASC webinars. This one received the most votes, if you like, on the poll that we did to see which webinars you wanted in which order. So this one was the one that you wanted first. So here it is. There will be more, but approximately every 2 weeks. We don't want to, replace your Netflix viewing in any way. We just want to try and give you useful information in a timely fashion. I'm not going to say any more about the Pink Book other than that, we are really pleased to have been able to sponsor this document. I've used it for ever. I've also known Kurt forever, who wrote it. So, for me, this is a Bible. It's never more than an arm's length away from my desk. I use it all the time when I'm answering questions to members. I use it all the time when we're looking at stuff for our own business. It's a brilliant document, and we are really, really pleased to be the sponsors of it. I'm going to now say a little bit about safe and legal. There's a little logo in the bottom right of that slide. It's not a formal logo. It's not one that you can attach to your business yet, because it's the logo for the Safe and Legal lobbying group that pre-COVID was trying to get all accommodation to be safe and legal. And that, now that we see restrictions being lifted, will be resuscitated. It involves about 40 organisations. PASC is the secretariat and tries to coordinate what we're doing. And that group will be writing a white paper ready for the consultation that the government announced on statutory registration in the Tourism Recovery Plan. So a proper, balanced, three-dimensional white paper. Okay, so you'll see more about that in PASC newsletters coming out during the summer. The consultation is not formally launched yet, so we're getting ourselves into pole position to be able to have a good positioning statement. Okay, I'm just going to run a couple of polls. Dalan's going to call up the first one. I'm going to just ask you, how many of you think you are pretty compliant, pretty fully compliant at the moment? So you're going to get a question on, do you believe your business is compliant at the moment? And you just tick yes or no. It's a straightforward question. And we'll give you a few seconds to answer that. It's not a catch question. We're not monitoring who's ticking which boxes. We can't do that. We don't want to do that. This is just to get a feel so that we can steer the webinar and future ones. Okay, so once Dalan has posted that one up, and the result will come shortly. Okay, well, 3/4 of you think you are and 1/4 don't. So again, we would probably have expected it to be a pretty compliant group that was watching, but let's see what happens. We'll ask the question at the end again and see if we get a different answer. The next poll, please, Dalan. This is how many of you have public liability insurance, and for approximately how much? The nearest amount on the okay. I was going to ask how much on that poll, but it's just a yes or no. That's okay. So this is not a legal obligation to have public liability insurance. That kind of surprised me when I found that out about 12 or 13 years ago. The only two insurances that you have to have by law are motor car insurance if you drive one, and employee liability insurance if you employ people. Those are the only two insurances that you have to do by law. So Wembley Stadium does not need to have public liability insurance by law. And if you saw what I saw, you'd think probably needs it, but there you go. Okay, well, 96% of you, so that is fabulous. So we can close that now, and I'll go straight on now to introduce the panel and get on with today's events. So, here we are. Nope. Sorry, everybody, I didn't realize, Dylan, you'd split the question into two. Could you just indicate approximately what cover you have, what public liability cover you have taken? And I'll then, when we get the result, I'll just cover that for a couple of seconds. But again, very surprised that this isn't something that would be law. You know, you have to have insurance to drive a car, but you don't have to have insurance to have people staying in your property. Seems a bit of a oddity. Okay, Dalan's going to do this. Right, so we have 19% at 1 million, 19% at 2 million, about half of you at 5 million, and about 20%, 17% at 10. 2 or 3 years ago, the number that was recommended by insurers was 5 million, because the cost of serious cases is astonishingly high. And I think our recommendation would probably be that you look at 10 million and don't all pass out. Going from 5 million to 10 million does not double your insurance premium. It added about 100 quid to ours to go from 5 to 10. So it's not significant. If you think of the kind of disasters that can happen, there was the Airbnb balcony disaster in Brighton a few years ago, which was hushed up and paid off. That would have cost getting very, very close to or more than 10 million pounds to resolve. So the costs of big cases, child slipping and being permanently injured in a swimming pool accident stuff, the costs are off the scale. So we'd certainly recommend you looking at 10 million. Right, now we're going to spin on. I'm going to introduce the panel and then hand over to Ross. So next slide, please, Dylan. Okay, we're welcoming Ross again. This is the second PASC webinar he's taken part in. We had the accessibility one, which you can still see is on the web. You can see the recording. Ross is head of business support for Visit England, so he has responsibility for accessibility. He has responsibility for the business hub. He has responsibility for the Pink Book, the awards program, and much more. So we've worked very closely together over the years. And it's a privilege to have him back again today. He will be followed by Beth, who is chair of Premier Cottages and owner of Kernock Cottages, and will give you a kind of owner's insight into this before we get to Kurt. Kurt is a director of the Tourism Alliance. He's also a director of PASC, and he is the author of the Pink Book. So any questions? You know where a lot of them will be going later on. So it's a privilege to welcome all three of you. I will then round up and do a Q&A at the end, so you won't hear a great deal more from me until then. So I'm going to hand over now to Ross Calladine from Visit England. Thank you, Ross.
Fantastic. Thank you, Alistair. Can everyone hear me fine? Perfect. Thank you for having me today, Alistair and Beth. Delighted to come and speak to past members and other members of the self-catering sector. I'm going to present a short introduction to our guidance for all accommodation and now attraction businesses around applicable legislation, and that will be an introduction to our main resource, the Pink Book. And as you heard from Alistair, Kurt, our managing author, will go into much more detail shortly. Okay, without further ado. Sorry, the slides are being a little bit slow. Okay, so just a bit of background. Alistair mentioned that Visit England provide a business advice hub on our industry website. If you haven't accessed that before, I do encourage you to have a look at the business advice hub. Most of it, 99%, is free to access. Very easy resource, and it's helping you to navigate a wide range of business support, not just support that's available from Visit Britain and Visit England, but support that is available from a wide range of external partners, including government departments, but also trade associations, DMOs, growth hubs, and others. So it'll connect you with a wide wealth of resources, and it'll give you lots of practical tips. And one area that we cover in detail is legal obligations, which I'm going to focus on through the Pink Book today. It helps you at all stages of your business journey. So it will help you if you're working on starting up or starting up a new element to your business, compliance, which we'll look at today, developing your product and keeping the quality development and in line with current consumer expectations, and of course the marketing and the bookability and the distribution of your product and service. Key sections, that there's lots of breadth to the business advice hub at the moment, and as you see there circled, if you look for know your legal obligations, that will take you into the Pink Book. But the COVID-19 section has really been invaluable for many tourism businesses over the last 18 months. That is where we will continue to signpost to the very latest guidance, and we are awaiting updated guidance from the government on step 4. Okay, so getting into the Pink Book then, this was a publication that Visit England, Visit Britain first published back in 1997, and it's now in its 11th edition. Pleased to say it's supported by our sponsoring department, which is the Department for Digital, Culture, Media and Sport, and the foreword is by the Minister. And delighted that this 11th edition is sponsored, as Alistair said, by PASC UK. So it's providing you as accommodation operators in England with all the information that you need to understand and comply with the legislation that's currently in place. The 11th edition has been expanded for the first time to now cover legislation that also applies to visitor attractions. The actual book itself, the physical copy, we tend to print that every 2 years, and issue 11 was published on the 1st of April this year. But it's also supported by a free online version. And Kurt provides us with monthly updates. So that's looking at recent changes and upcoming changes to legislation and bringing your attention to these. As sponsors of the 11th edition, PASC is making a free copy available to all members, and also any member of the Visit England Quality Assessment Schemes is entitled to a free copy. So I mentioned about the online version. I actually think the most popular thing is to have the printed copy as that reference document that Alistair mentioned he finds so useful. You can mark up pages and pick it off the bookshelf and refer to it. But equally, checking back on the online version for any updates within the 2-year period. If you would like to purchase a copy, it's available via the Business Advice Hub, and it's £12.49 for a copy to be delivered to you. This is the only chart I'm going to show you guys, but it's just really to show that visits to the Pink Book pages of the Business Advice Hub account for almost a third of all visits. So I think it's fair to say it is probably our most popular resource, the Pink Book. And that accounted for over 100,000 page views in the last financial year. We obviously include a lot of outbound linking to the information that we're giving. And just to show you some of the most clicked links, information about licenses is always very popular. So there was some information about the MPLC licensing in a document from UK Hospitality and the Beer and Pub Association that was scrutinising that new license arrangement. That became our most popular resource last year, and currently a big interest in understanding the rules around employing under 18s. There is a lot of staffing issues and restrictions for the industry at the moment, so it's not a surprise that that one is up there. Fire safety, is something we're going to touch on in a number of our presentations today, remains popular. And as we move down, you can see there's some other licensing links and planning and entertainment licensing that are popular as well. One thing I wanted to pull out also is fire risk responsibilities. There is a responsibility to complete a fire risk assessment, and Visit England have for many years now provided a tool for you to develop your own fire risk assessment document. So we have a template that was updated in February 2020. It was developed in collaboration with the National Fire Chiefs Council, and it replaced our previous tool. So this is also very popular. So just a summary today, the useful links, please do check back on the Business Advice Hub, bookmark it, and you can find links in all of our newsletters and our bulletins that we're doing during COVID. The link to get you straight into the Pink Book Online, visitengland.org/Pink Book Online. Some other popular links currently is the We're Good to Go industry standard, our COVID-19 consumer sentiment survey that continues. And if you're not already getting our 2-weekly newsletter, please do sign up, because all of Visit Britain and Visit England's latest guidance, news and intelligence goes into that newsletter. Excellent. Alistair, that's the end of my presentation. I'd like to pass over now to Beth Bailey, owner of Kernock Cottages and of course chair of Premier Cottages. Over to you.
Thanks very much, Ross. Could you unshare your screen, please, so I can share mine? Brilliant. Right, where are we? Share screen. Where's mine gone? There we go. Is that showing now? Is that showing? Yeah, okay. Right, I wanted to come at this from a slightly different angle, that of the owner. There is obviously this thing called the law that we are obliged to abide by. I spend quite a lot of time looking on Facebook at some of these hospitality forums, and the thing that I find somewhat alarming is that there are often lots of people asking for advice, and a lot of the advice that appears on these forums says stuff like, it's not law, so you don't need to do it. So beneath that strata of the law, you as an owner, to protect yourself and cover your back in case of worst case scenarios, need to think about lots of other stuff. So there were lots of comments during COVID, for example, about what was guidance and what was law. So you have to think about whether you need to observe guidance. You have a duty of care under health and safety legislation. Obviously, you have a moral responsibility. Also, you need to look after your business, and you need to make sure that if anything goes wrong, your insurance company is going to cough up. So it's not just a matter of observing the law to the letter. It's really whether you need to do all the other stuff so that you're looking after your interests. Fulfilling your legal obligations is one thing, but your primary job as an owner is to protect your business. And under the catch-all of the health and safety legislation, the guidance versus law thing is something that's very much worth considering. So, for example, I've got 4 hot tubs. There is guidance published by the industry on hot tubs, which HSG 282 says, for example, that if you have a hot tub for commercial use, you have to drain it between guests, you have to test it every day, you have to have inline chemical dispensers. So imagine if I say, that's guidance, it's not law. So I'm going to stick in my hot tub with the little mushroom floating around in the top of the hot tub, which has got tablets, chlorine or bromine tablets in it, which the guidance says you shouldn't, but it's not law. So then imagine that a guest child takes one of those out and eats it and dies, which is totally plausible. You wouldn't have a great deal of a leg to stand on if you stood up and said that was only guidance, it wasn't law, and your insurance company would probably not give you a very sympathetic hearing. So be really careful with that guidance versus law, and there's lots of proper resource around, the Pink Book, Visit England. So please try not to take your advice on matters of such great importance from Facebook. Another bit of legislation that we don't think about often, and I know there are a lot of kind of fairly new to the industry people on the call, is the question of, am I a business? And this is important from a tax legislation point of view. So there's something called the FHL, which is Furnished Holiday Lettings Qualifying Rules. If you fulfill these, which is to be let on a commercial basis with a view to making a profit, be available but not necessarily booked for 210 days a year, and be let for at least 105 days a year, then you qualify as an FHL. And that does confer certain advantages on you, specifically on tax. You can get full relief for the cost of purchasing things. You can offset losses against the income of that property, for example. And there are capital gains benefits. So that's one thing that you want to look at. And if it's not something you've heard about, please do go and see your accountant or your bookkeeper, because that can be hugely beneficial to you. So if you've decided, yes, I am a business, then you need to register for business rates. Actually, you should register for business rates if you're doing it commercially anyway. A lot of people are nervous about registering business rates because they think it costs them more money. Actually, if you have a tool, because you get small business rate relief, so often you will benefit from switching out of council tax and into business rates. However, you can't have your cake and eat it. If you are a commercial business, you need to pay for your waste collection. And I can say with some confidence that because of COVID and the income loss that local authorities had, they are going to be tightening up very much more on this kind of thing, on chasing self-caterers who dump their rubbish into the domestic than they have previously. There's lots of legislation you need to comply with. Kurt's going to talk more about that. Alistair's mentioned employer's liability, which is a legal requirement, and public liability, which isn't, but you need your head screwed on if you're thinking about not having it. And you need to risk assess any changes. And I say any advisedly, I'll come to that in a minute. If you decide that you're not a business because you're not letting for 105 days a year, really you just want to let your second home out for a few weeks so that you get free holidays, well, bad luck, because whatever size you are, you still need to comply with the fundamental legislation and you still have a duty of care. So you don't get off that lightly. And lack of, there is some people think it doesn't apply to them because they're not doing it professionally. It's very alarming. If you go on something like Airbnb, the number of listings in the UK, and I think last time we counted it was something like 43,000, did not have a smoke alarm in a property that they are letting out to members of the public. When the worst happens, saying, I didn't know, it didn't apply to me, it will be no defense whatsoever. So, even if you're only doing it a few weeks a year, make sure you are ticking all the boxes that you need to tick. From an owner's point of view, so all of us kind of sit there thinking, what can we bring, what can we add to our business that's going to make the guest experience better for our guests? So we invest in, pools and play equipment and trampolines and memberships of this, that and the other, and DVDs and what have you. You have to always think about what that is going to do in terms of bringing not just joy to your clients, your guests, but risk to you. Because especially with these big investment items, they are things where lots of accidents can happen. So you need to, you can't necessarily always prevent the accident, but you need to make sure that you prevent individual risk assessments for each of these activities. And you need to check with your insurer whether you have done enough. So as I mentioned, I've got 4 hot tubs. I'm insured with the NFU. They did not want to insure me unless I could guarantee that there would be no solo bathing in my hot tubs. Now, A, there's only one of me and I've got 4 hot tubs, and B, I've got better things to do than perch on the side of each hot tub just waiting to spot whether there is some drunk guest at 3 in the morning who decides to take a dip on their own and drown themselves. They didn't want to insure me, but obviously it's not reasonable and I can't really put CCTV in. That's very intrusive for guests. But we did come to a compromise, which was that I would write on my website and on all the notes in the cottages and tell them when they were here that they should not bathe alone, they should use the buddy system. The insurance company agreed that, you know, that's reasonable. They're a bit like sheep. There are always people who will go to the extra lengths to damage themselves. But as long as you've done enough to cover yourself, that should be sufficient. Also, make sure that these things are properly serviced. There was a recent case of somebody who had slipped on a hot tub decking, and there were photographs produced by the guest, and the decking was green with slime. So absolutely a trip hazard. If you've got your hot tubs on decking, pressure wash them regularly and put anti-slip surfaces on. You know, if you've got children's play equipment, get it regularly inspected. There's a guy who rang me the other day in Cornwall. He does a quarterly visit for £25 per visit, no matter how much equipment, 25 quid. He's ROSPA registered. He'll give you a bit of paper that says your equipment is safe. It's not worth not doing it. And lastly, put in all the bells and whistles you can to protect the guests. So rubber matting under the play equipment, UV under the hot tubs, etc. Alistair,
Beth,
you're waving.
Try turning your video off just for a second because it's beginning to break up a little.
How do I do that? I'm going to have to...
Just stop video and then you can still...
Yeah, I'm going to have to come out of screen sharing in order to do that, I think. Oh, no, stop video. Is that better? Okay, we'll try this then.
And the signal's better. That's great.
Okay, that's fine. We can do that. Right, so I mentioned risk assessments. They sound really scary, but actually, you know, a lot of it's intuitive and there are some templates. This is one I did for my insurance company on hot tubs. I'm not saying it's a perfect one, but it does say thought about things like how accidents might happen, drainage, they might overheat, they might get electrocuted, they might swallow chemicals, and what steps I have taken to minimize that risk. And you need to do these for basically for most of the stuff that you're going to do. There's some less obvious stuff too. So you've got a new cottage, you've spent lots of money doing it up, you don't really want to spend too much on furniture, so you go on Facebook Marketplace to buy loads of stuff at really brilliant prices. Just be careful, if it's not an antique, it needs to comply with the Furniture and Furnishings Fire Safety Regulations 1988. You know, so it's stuff like that. Don't do things haphazardly, think about it. Another one, which is a real hazard. So your guest says, oh, you know, can I hire a hot tub, hire a bouncy castle, bring in a chef, whatever. And to be nice, you just say yes. Absolutely be really careful to double check this and make sure that your T&Cs cover you for this. We've written a PASC paper on allowing third parties on site, where there are some real horror stories. There's a real live member who had a group unbeknownst to them to bring in some zorbing balls. There was then an accident where somebody got injured. The zorbing providers were not insured, so the guests came after the owner. You've got a nice expensive property, you've probably got some dosh, even though they were unaware of it. They did defend themselves successfully, but obviously it cost them legal fees. Make sure you're covered against this. And other nice things we try to do, I see, you know, kind of lots of people saying, oh, you know, I'm going to get DVDs, or I'm going to put Alexa in, or Netflix, or whatever. Just double check what licenses you need. Worth mentioning the TV hotel license, which may seem the obvious one, but lots of owners don't seem to be aware that they can have a hotel TV license that covers up to 15 units. And if you live on site, it will also cover your own house. And that is £157, I think it is, which is the same as the TV license. So don't go buying an individual TV license for your 5 cottages all on one site. I think there's other information on the PASC website about the various licenses. So I'm not going to dwell on that, but it is, you know, think about the unintended consequences. Welcome packs. Lovely to get a welcome pack. Just have a quick think about what's going in it. If you are giving them alcohol, technically you require a license, though Kurt may well say he's never heard of anyone being prosecuted for giving a free bottle of wine. If you're making homemade stuff, just remember that poor girl on that aeroplane who bought a sandwich from a well-known sandwich shop, took it on the aeroplane and died because she didn't know it had sesame in it. If you're making homemade stuff, make sure you let the guests know what the ingredients are. You just don't know what their allergies might be. And if you're making homemade items, check whether you need a food hygiene certificate. There is a PASC paper which is going to be produced on welcome packs, which will have more information on that. The other thing is that nothing stays the same. Safety information changes regularly. Our business is quite child friendly. We used to provide we provide lots of baby kit. Used to include baby plug socket covers until I had somebody involved in the child safety movement who said, "Oh no, those kill children," and apparently they're no longer recommended, but they are still sold. So if you're providing those, be really careful. Stop providing them and go and look it up. And if you've got blinds that are a few years old, they probably don't have the safety brake mechanisms to stop children strangling themselves. So, keep up with legislative changes. It's not all bad and homework. One of the really good things you can do, which guests really appreciate, is that you can use all the stuff you do to give you content for your social media. So guests, we just had all of our stuff safety tested, to keep you safe. We have joined the Safe, Clean and Legal thing. We've just replaced all our smoke alarms. It shows, it may not be the most exciting of posts, but it does show guests that you are taking care of their well-being and safety. So just to sum up, avoid the bear pits, risk assess everything, and do a separate risk assessment for all the big things like hot tubs, pools, play equipment, welcome packs. So if something does happen, you can document and show your insurance company that you had thought about these things and done your best to mitigate risk. Check with your insurance company if you're doing any new stuff. Will they let you have a hot tub and cover it? Is it covered? And negotiate if you need to. Get annual inspections by ROSPA on things like kids safety equipment. And yeah, the biggest thing would be don't use Facebook as your main source of information on what is a legal requirement. A lot of these people are very well intentioned, but they're not necessarily even in your country. You don't know when people answer where they're based. So there are resources that you can use, and keep an audit trail by documenting everything. So that's me, and now I'm going to pass over to Kurt, who is he's the man. He writes the books that keep you safe. So Kurt, over to you.
Thanks, Beth, and thanks for a great presentation. I think I can actually kick back now because you've said most of what I wanted to say. Thanks to Alistair for the invitation to come along and speak to you today. I'm going to talk a little bit more about the Pink Book and what's in it, how it's laid out and how it can help you, but also kind of draw your attention to various pieces of regulation in the Pink Book, which you need to be aware of. Obviously, we can't cover everything today, but if I go through the basics with you and say, these are the things you really need to concentrate on, because there's about 9 pieces of legislation that if you nail those, you've nailed probably 80–90% of what you need to do. So before we start, let's have a bit of a pop quiz. And we've got a poll coming up. And it's basically, how many different acts and regulations do you think apply to your business? So if we could have the poll up and people can kind of see, well, make an estimate there of how many rules or acts and regulations apply to what they do. Okay, I hope everyone's done that. And if we pop up the answer, yeah, it's quite a good range of kind of most people around the 50 mark there, with the bit either side. So somewhere kind of 25 to 50, it seems to be about to where people are saying the average lies. Okay, if we could go through to the answer. And the answer is at least 72. So I went through the Pink Book this morning and kind of counted up the acts and regulations that we reference in there, and I found about 72 pieces of legislation. So the moral of the story there is that there is a lot more legislation out there that covers your activities than you actually think there is. And it's changing all the time, and it's important that you keep on top of this. And this is where the Pink Book comes in to help you, because some of the regulations that apply to you are pretty exotic. You're not expected to know them. So this is a resource that we've designed that you can kind of dip in and dip out of, rather than you have to actually read it as a book from beginning to end. It is a reference guide that you can put on the shelf and pull down whenever you need to look up specifics as they apply to a situation that comes to hand for you. So if we go to the next slide, and this is the way we've set it out. Basically, the Pink Book loosely covers the process by which you set up a business and the customer journey through your business. So, you know, that starts off with what licenses and consents you need to operate in the first place, the legislation that applies to your marketing. So you set yourself up. How do you market to your customers? What you should do, what you shouldn't do, what you're allowed to do by law. And then once you've marketed to your customers, how do you treat your customers through the booking process, and what their rights and responsibilities are, and what your rights and responsibilities are if things go wrong through the booking, with cancellations and such like. Then once they've arrived, you know, the food and drink that you serve them, making sure that that's hygienic, making sure that your premises are safe, not just for customers, but you have a duty to protect staff and also contractors that come to your premises. So you've got to actually think about people who come onto site at your place to do maintenance work for you, for example, or deliveries. You've got to make sure that your premises are safe for them as well. And then we go on to things like employment law in terms of who you can employ, what hours you can employ them for, setting up things like a workplace pension for them, and then the tax requirements of how to treat your business. So it's a fairly logical layout to the book. And then we go on to the next slide, which has the layout of every section. It starts off by telling you what are the key requirements. So the 3 or 4 things that you really need to know about each of the issues. And if you comply with those 3 or 4 headline things, you've pretty much got the rest of the chapter sorted out. So the key facts: does the legislation apply to you? Because it's one thing everyone hates is reading through something and then realizing it doesn't actually apply to you. So this is up front, ask you a couple of questions about what type of business you operate, and says whether or not the legislation actually applies to what you do. Then it goes into what the legislation actually says, and then how to comply with it. And if you need further information on how to comply, or you've got an issue that's more complex than what we lay out in the Pink Book, then there's linkages at the end to further guidance where you can get real kind of fine-grained detail on how to comply with the legislation. Okay, if we've got the next slide. The other good thing about the Pink Book is that basically we highlight new content. So you may think that you've got a good handle on what's going on. Each new copy that comes out, it's highlighted in there about what's changed since the last version, so you can bring yourself kind of up to speed. So for example, in the new version, we've got information on the new points-based immigration scheme for employing staff. from outside the UK. And that's not just getting them into the country, but also you have a responsibility to check the status of any employees that you take on, and whether they're able to work in the country. If they're not, then you are responsible and you can be fined for that. There's upcoming legislation on single-use plastics on the property. There's new information on minimising your risk under health and safety legislations, and whether you can refuse a booking, which is a very kind of pertinent subject at the moment. We also give you a heads up on legislation that is about to change, because obviously there's very much a lead-in process. For example, just at the moment, BAY's government department is reviewing the package travel regulations, which is actually something which you don't think applies to you, but it probably does. If you ever get into an agreement with someone through your business, for example, there's a horse riding company and you say, come and stay at my place and I'll give you kind of 2 people can go horse riding and I'll include it in that package. Or someone says to you, I'd like to come and stay with your place. Can you organise someone to come in and cook for us? That would actually constitute package travel under the regulations as they stand at the moment. It's something that we're trying to change, but you need to know about it. And also the government is undertaking a big review of planning rules. So these may well change and provide you with a little bit more flexibility to undertake the expansion of your business. So this is kind of how we lead you through using the Paint Book. Now, the next bit I'm going to get onto is what you need to comply with the vast majority. So this is real headline stuff, but it'll point you in the right direction, and you can see if there are any gaps in what you do. So if I can have the next slide. These are the 3 key requirements when it comes to health and safety. If you do these and you do them well, then you're pretty much set. Okay, you need to do a health and safety assessment, you do need to do a fire safety assessment, and if you've got gas, you need to have gas safe certification, and that certification needs to be on a yearly basis. So every year you've got to get a new fire safe certificate if you're using gas, and that's a legal requirement. The other 2 are also legal requirements, and for health and safety, you've got to go around your property and assess all the risks to, again, customers, your staff, or contractors that come on site. And those safety issues can range for everything from working at heights to chemical hazards to trip hazards, physical hazards, ponds that you may have on your place, electrical hazards, yeah, anything that could possibly jeopardize the safety of someone who's on the premises for any purpose whatsoever. Now, there is not well, the legislation as it stands is if you're a very small business with under 5 staff, then you don't actually have to write up your fire safety assessment. It can be just a mental process. The problem with that is if something goes wrong, you get sued, taken to court. It's very hard to convince a judge that you went through a mental process and that was an adequate mental process. So we recommend absolutely everyone, no matter how small your business is, write up your health and safety assessment, because that is what you will depend on if things go badly wrong and someone takes you to court. Now, wrapped up in that as well is you get a lot of chat, as Beth was saying, about things that are not legally required. For example, there's an odd bit of legislation which says that if you have a long-term tenancy, say you're a landlord, you have to have CO2 monitors on your property. That doesn't actually apply to self-catering properties. So there's a lot of chat that you get about it's not a legal requirement, I don't have to do it. That's absolutely fine until something goes wrong. If you got kind of pulled in front of a judge and the judge said, why didn't you put in a CO2 monitor when you know that you have gas equipment in your property, and you say, but it wasn't a legal requirement, you can still be told that you've been totally negligent to your guests and therefore you can be convicted for negligence. Okay, so don't take something as not a legal requirement, meaning you don't have to do it. Another good example of that is in your health and safety assessment or your fire safety assessment. You should have things such as cleaning the chimney. If you've got a chimney on your property, you can't just leave it and in 10 years time there's a fire in the chimney which kills a couple of your guests and go, it wasn't a legal requirement to clean my chimney. That's being negligent and you can be sued very badly for that. Okay, so you should take that kind of process throughout your health and safety assessment and your fire safety assessment. Again, as Beth mentioned, PAT testing, not a legal requirement, but if you don't do it, you can be sued for being negligent to your guests. So we always advise, take a kind of a risk cautious approach and treat it as kind of you would want other people to treat you if you were staying in a place. You would expect them to regularly monitor anything that could be of risk to you and make sure it's mitigated to the best of their ability. And that's the approach that you should have. So if you do those three things, write them down, keep them updated, because any changes to legislation, any changes to your property, any changes to work processes, how cleaners come into the place, what cleaning materials that they use, any changes whatsoever have to be updated. So don't just put your risk assessments on a shelf and leave them. Go back to them every year to make sure that they're still relevant, they're still up to date. If we go on to the next kind of batch of legislation, the three things that you need to know about consumer protection are the consumer contracts regulations, the consumer protection regulations, and the general data protection regulations. Now, again, all three of them you really need to know, and they're all in the pink book, but consumer contracts regulations covers everything to do with bookings, because when you make a booking, you have formed a contract between yourself and the customer, and the various things that you can do and can't do in that contract, or when that contract is broken. If you don't, for example, have a contract in place, you cannot charge the consumer the whole of the amount for renting the property. Okay, you have to go through a process of actually determining what your actual losses are. So you have to take away things that you didn't provide them in terms of hot water, heating, cleaning of linen, all that type of thing, VAT, away from it. And it generally ends up being, you can only charge them about 2/3 of the amount. Similarly, if you accidentally overbook or something happens to one of your properties and you have to terminate the contract with the consumer, you are actually legally responsible of finding them somewhere to stay, and you've got to find them somewhere to stay that is of equal, if not better quality than the place that you own yourself. You can't just say that's bad luck and walk away. Consumer protection regulations, that covers everything about marketing your property. People have a thought that, for example, anyone who stays there, if they can just send out marketing material because they were a customer, therefore I'm sending them material. Actually, people have to opt in to you sending them marketing material, even if they are former customers. So you actually have to have a process in place where a person actively says, yes, I allow you to send me marketing material. Also in that is, you can't just buy a list of email addresses from people who will email you and say, we've got all these wonderful customers. That's not legal because they haven't given their consent for you to email them. Then there's general data protection regulations in terms of what you can do with, in terms of gathering personal data from your customers, and that personal data can be collected in any way from what they kind of fill in a registration form, what they tell you about what they like in terms of maybe I want the Times newspaper, or I don't eat gluten foods, all that type of thing. That's personal data. Anything that you collect in the way of video, if you've got CCTV, that is personal data. And how you treat that data is incredibly important these days. And also having people contact you and say, I don't want to be remembered. So you've got to actually delete all their data off the system and be able to show them that you have done so. So again, if you comply with those three, you've got most of the consumer protection legislation under control. And the next bit, great, is the approvals. And there's kind of three main approvals that you need to operate your business. One is change of use, various, depending on the format of your business, you may need change of use to convert it from a residential property to a commercial property. Most cottages don't, but if you are going to do a purpose-built property or expand the property for more than just residential use, then you will need change of use permission from the council. There's all the copyright licensing that Beth mentioned, from everything from TVs, movies, DVDs, even radio. It's all covered by copyright licensing. So any material that has a copyright attached to it that you are giving to a customer is covered by this. Even if it's, for example, just a free DVD that you got as stuck onto a Sunday supplement, and you leave that in the cottage for the customers, that is actually making a commercial profit out of copyright material. And then finally, alcohol and licensing. And as kind of, again, Beth alluded to, there is no such thing as giving people a free bottle of alcohol. The legislation it kind of treats you as, if you give someone a basket, a welcome basket, you have factored that cost into what they are paying for the property. Therefore, the customer is actually paying for it. And you need, theoretically, an alcohol license. So you need to be aware of that. And also, if customers emailing you, you have a service whereby you collect their groceries for them and put the groceries into the property. You are buying alcohol and then kind of charging them for it, and you need a license to do that. So that's a real romp through the legislation, and that's the end of my presentation. So kind of happy to provide any answers to questions that people might have. I'll pass back to Alistair.
Kurt, thank you very much indeed. Beth, who's trying to reconnect, I think her connection's rather weak. Thank you, Beth. And Ross, thank you very much indeed. I have just one quick slide before we go to the Q&A, which if Dylan, you could pop that up, and I will do a summary, and then we'll get to the Q&A. We've got lots of good questions to answer. So once the slide is up, Dylan, I'll begin. Okay. Lots and lots of questions come into PASC every single day on subjects that we touched on today and that are in the Pink Book. Yeah, by all means, ask the questions. But as we said, there are great resources. There is the VE Business Hub. There's the online Pink Book, or you can get a copy by any of the means that Ross suggested. If you're a graded Visit England business, you'll get a copy. If you're a PASC member, you'll get a copy, or you can buy a copy from VE. Lots of trade associations will answer these questions for you. So, you know, join a trade association and they'll help you find the answer. The insurance angle I wanted to cover, we get lots and lots of questions about this because insurance companies give different answers, and I will post some of the specific questions about that to the panel that have come in. But essentially, you have a duty of care, and whether you know, you think that when it says PAT testing only has to take place, you know, in a reasonable time. If you don't do PAT testing in what is a reasonable time, then you're definitely not covered. And the trouble is, what is a reasonable time? This is the way the insurance companies are slightly shifty, in my view, that they don't necessarily stipulate, but they may well actually refuse a claim on the basis that you haven't done things in a reasonable time. So I think you need to make your own assessment on this. I mean, we do our PAT testing every year, and the reason we do our PAT testing every year is because every time we get PAT testing done, we find about 6 or 7 things that fail. So, you know, we want to know that and replace side lights or kettles or whatever that have become dodgy. We do it at the same time as the fire thing. We've got a great deal with Dorset Devon Fire. If anybody is in the southwest, I'm happy to pass on his details. He's very good value, very good. So these things don't have to cost a fortune either. I know some people struggle to get this in some areas, but please, if you have a good person, recommend them to PASC and we can put them on the PASC suppliers list. So you are protecting yourself as well as your consumers by doing things properly, and that's a really important point. I'm going to call this just one night, you know, one night only. If you let your property for one night only, this stuff applies to you. This is not, you know, all the stuff you hear about amateurs don't need to do it, only professionals, is poppycock. You know, Kurt and I have met fire officers who have said, absolutely, this applies to anybody doing it from one night only. And you couldn't, again, Kurt's examples of standing in front of the beak. If you said to the judge, well, I was only letting the property for one night, so I didn't bother putting a fire alarm in, I think you can kind of work out where that might lead on your own. So you don't want to get into a position where claims get denied. You know, otherwise you've wasted the insurance premium as well. So, you know, get it right first time. I think there's a real opportunity to make compliance a feature of your business. We've done it forever here, and the guests love it. It makes them feel comfortable. It makes them feel that we care about them. It makes them feel that we're a good business, and people like to do business with good businesses rather than amateurs. So again, it's a really good way to promote your business. And get ahead. As I said, statutory registration is coming. We'll get some questions on that in the panel from the panelists. So it's coming. So get ahead. So that's my quick summary. I'm now going to start asking the questions of the panel, and I'm going to start with on the statutory registration. I'm going to start with a question on that actually, which is, Kurt, in Scotland, we know exactly what the shape of the statutory registration is going to be, and it will cover all of this. We're pretty confident that Wales will cover all of this in their statutory registration. What's your view of what statutory registration in England might look like?
Yeah, the way that I'm approaching this is that we need a system which is very simple, that is very cheap, and gives people implied consent. And what I mean by implied consent is that if anyone has registered their business because they sell food or drink, you have to go onto the local council website. You have to tell them, I'm a business that's selling food and drink, here I am, this is my details. That the simple filling in the form gives you consent to undertake the activity. So this isn't licensing. Licensing is where you apply for it and you can be turned down from being accepted. This would be, you know, if you fill in the form, you just get on and do your business. All you would need on that on a very simple basis would be, here's my contact details, here's where my business is, and this is a brief description of what I'm doing. Yeah, you could embellish that if you wanted to by uploading proof of certain documents, maybe your insurance, maybe, you know, your public liability insurance, maybe your health and safety or fire safety assessments or gas mark. You could do something like that, but really at a basic level, it would just be, this is who I am, this is where I am, and this is what I'm doing.
Okay. My view on statutory registration is it's it's necessary. We need to try and raise the bar. Particularly what we'll see this summer is massive over-tourism in some areas, with everybody jumping on the bandwagon and not doing it very well, and certainly not doing it very safely. That will bring problems, disrepute to the sector, and all kinds of other pressures, calls for taxation on tourism because of over-tourism. So I think we need a fairly robust statutory registration scheme, and that will be what we'll be presenting in a white paper. I'm going to move on from that and just say a couple of questions have come in about regulations. Up until the 19th of July, being COVID ready was law, and from 19th of July, Freedom Day. What happens then? So I'm going to go straight back to Kurt on that, because we had this dialogue yesterday, so I know you've got the answer. And so what happens about all the cleaning protocols from the 19th of July, Kurt, in England?
Sure. There is a series of guidance documents for various components of the tourism industry. We call them the kind of primary guidance for particular industries. They're working safely with coronavirus for accommodation businesses, and then it's working safely with coronavirus for restaurants and pubs. Those are the primary guidance. That will all be updated ahead, well, probably this week, for step 4. And what it will do is basically lay out the guidance for businesses as to what is best practice in terms of step 4. So the legal requirements will go down to from having fines associated with them to just being guidance, but it will all be laid out there in those books about kind of what you need to do, still in terms of cleaning protocols or about social distancing, but it will only be guidance rather than actual legal requirements.
And we would say, as PASC, it might only be guidance, but you should really continue with the protocols. The pandemic is still out there, and we need to do every bit that we can to make sure that we don't get ourselves into a lockdown again. The damage that the lockdown has done to so many of your businesses, we can play our part in preventing that. Again, we talk a lot about customer confidence on these webinars. I can absolutely tell you that our COVID protocols here at Higher Wiscombe give the customers massive confidence, and absolutely they love it. It makes them feel really positive, and they come back and they'll say, we went to a place and they weren't doing anything properly. Be the ones that do it properly. Look after your customers and look after your own staff and business. So yes, it'll be guidance from the 19th, but please follow it. Ross, I can see you want to come in there.
Yeah, just to build on what Kurt has said there, I think language from the government in the upcoming guidance will shift more to encourage. The word encourage will be used quite a lot. I think the word expected may be used a lot. And in the same way that this change in step 4 is shifting responsibility to the individual, I think it's equally shifting the responsibility and the decision making to the business. But infection levels are going up at the moment. Customers, as you say, Alistair, guests are going to be looking for continued reassurance post step 4 that businesses are continuing to take their health and safety seriously and continuing to take steps in this space, whether it's a legal requirement or not.
Thank you. Beth, did you want to add anything to that? I saw your hand go up.
A couple of bits. To remember that self-catering, which is our industry, is probably the safest in terms of COVID. So a lot of people who are nervous will choose a self-catering holiday for that reason. There are also a lot of clinically vulnerable people out there for whom, you know, they can be double jabbed, but apparently the vaccination is not as effective. So they're not getting 90% cover. And while you may look at the headline number and think, well, there aren't that many, so who cares? Everybody's going to bring, you know, who's bringing granny on holiday, or a lot of these groups will have one individual who may be clinically vulnerable. You want to be doing everything you can to reassure your guests, not not ditching the COVID cleaning. It's really important to keep it going.
Okay, thank you. Right, I'm going to belt through a couple of questions that I can answer very quickly, so we get some answered. A lot of questions about alcohol in hampers. You do need an alcohol license to even give alcohol away. They're not terribly difficult to get, but they do have a cost attached to them. We will be doing a hamper paper as PASC, which will cover all of the costs, how to get these licenses, how to do food preparation, whether you can make chutney and how to do it. There are ways that you can do all of these things, that you can protect yourself and protect your customers reasonably easily. And we are just in the process of finishing. That will be about 2 weeks work to complete that paper, and that paper will be available from the PASC website. So all of the hamper, food production, labeling, licensing costs will be provided in that paper, which is a work in progress. So I can't, and I don't specifically think we can answer individual questions about jars of chutney and stuff at the moment, but we will be able to in the paper. Okay, I mean, don't over worry about this. You need to comply, and when you've read it, read the paper. But I've never heard in 15 years of anybody being prosecuted for giving somebody a jar of chutney. So you have to keep it in perspective. There are probably things that we could do better to make sure that we're looking after people, and that will be in the paper. But I wouldn't suddenly go out there and pull all of your hampers back this Friday while you wait for the PASC paper. So you will get that, and it will explain those. A question about accidents in self-catering accommodation. It's a really good question. Minimal, really, compared to the number of nights stay, much lower than in many other places. Perhaps lack of bars might be a contributory factor to that. I don't know. But when a lot of people who had larger properties were saying, what if I change my property to a hotel? Can I take bookings? We researched the insurance implications of that. And insurance for a hotel is off the scale compared to insurance for an equivalent sized self-catering number of bedrooms. And that is because way more claims in hotels against the businesses than there have ever been in self-catering, and that's why we pay less for insurance. So again, just because the risk profile is low doesn't mean the risk profile is non-existent, but it is low. So those some questions there. There was one that I promised I would ask early on, and I need just to find that. If you just
so what about EV and stuff?
No, yeah, that one. But there's an awful lot of stuff going around at the moment on the internet about I can never get the right letters in the right order. EIHR, whatever it is, the electrical certificate that we're allegedly supposed to get every 5 years. Some people say it doesn't have to be every 5 years. Some do. Again, this is one of those really nasty guidance ones that Kurt was applying. If you've been running your self-catering holiday complex for 12 years and you've never had one because the guidance doesn't sort of stipulate a date at which you've had one, and you had a problem that was caused by electrical, the beak is going to be hammering you. We've done one here in lockdown. We used lockdown as a chance to do one. They do find faults in the system, so they are worth doing. Insurers might not insist on it, but if you haven't had one, I still think it gives them, even though they've said you don't need to have one, if you haven't had one for 7 or 8 years, I bet they come round and say, oh, it's an electrical fault, you haven't had one. So I would absolutely do one, because if you're going to do a proper fire risk assessment, what part of doing a proper fire risk assessment wouldn't be that you would check the electrical functionality on your business? So it's not the answer a lot of you want, because you don't want to do them, because they're not inexpensive. But I believe every 5 years would be the minimum that all businesses providing paid accommodation should do one. And if you do an EIHCR, whatever it is, I'll get it right in a minute, that does not mean you don't have to do PAT testing. They are two completely separate regimes. Okay, and because PAT testing is for things that you move around, and therefore the flexes get damaged, there is a much more high likelihood that some of those items will begin to fail. And as I said, every time we do it in January, we get 8 or 9 things, bedside lamps failing and stuff. So PAT testing at the max, I would recommend 2 years. Obviously, any product that you buy that's under guarantee doesn't have to be PAT tested while it's under guarantee. So, you keep a little book on it, and that will answer that. Right, I'm going to move back to some more general questions. we've seen a lot of stuff come through, Kurt, about PRS and PPL, and pre-COVID, there was some activity going on these ghastly licensing things. What's your take on where we are at the moment on that?
Yeah, it's a very unclear picture, to be honest. Obviously, the copyright collection agencies want to maximize their return. And so they are in the position where they tell everyone that they need a copyright license. Some of the trade associations, especially UK Hospitality, have challenged the legality of them wanting a copyright license in certain circumstances. For example, TVs in people's bedrooms, and there is a uneasy kind of truce between some of the trade associations and the collection agencies about what they can legally ask money for and what they can't. Certainly, if you are paying kind of music or films or even just TV in public areas, then that is definitely an area that you would need a copyright license for. When it comes into kind of the more personal space of rooms, then it's a little bit grayer. But it's something that we need to get some clarity on, because at the moment, what the collection agencies tend to do is just go out and bully people and kind of assert that they have a right. And if you don't give us the money, we will either double of the charges or take you to court. Yeah, all I can say is that it's slightly grey area. The Pink Book, we go into it in a bit more detail, but if you have any queries about it, feed them through and we'll try and deal with them.
Okay, so that, I mean, this is on the long list of lobbying stuff that we were dealing with before COVID came along, to try and seek clarity, and we will continue to do that. We believe that these licensing things have now become very active now as we come out of lockdown and are chasing people quite hard. Okay, a lot of questions about if the property is let through an agency, how does this fall in terms of obligations of the agency? I think I'm going to ask that of Kurt first, and then Beth, if you'd like to follow up with an opinion on that.
Yeah, a lot of it would depend on what your contract with the agency is. So it's worth checking that out. But you would probably have what is called primary responsibility, because you are the owner of the property. So in the first place, it's your fault, unless you have a contract with the agencies that says otherwise. But the agencies can also be held responsible as kind of a secondary responsibility, that they shouldn't have advertised a place or had it on their books if they didn't do due diligence in making sure that that property was kind of safe and legal for people to stay there. So there is responsibility on both parties, but primarily the responsibility would be yours because you are the owner of the property.
I think that the other thing to take into consideration if you are letting through an agent is the GDPR implications, because if the guest has booked through an agency and is technically the guest of the agency, the customer of the agency, not the customer of the property owner, then you probably do not have the right under GDPR to contact them, despite the fact that the government will probably ask you to store details of names and addresses of any guests over the age of 16 until September, or for 21 days. So GDPR is a grey area as far as the agencies is concerned, in terms of what you can do to subsequently market to those guests, and you would need to check.
Okay, I think if you look at a kind of an OTA contract, it would be absolutely stating that it has no responsibility whatsoever for the property offered. I can't remember off the top of my head, but I think it's clause 1.2b in the Airbnb customer contract that says we don't say that the property is safe, legal, or in fact even exists, which is a pretty robust clause in denying any liability. So again, as Kurt said, you need to see what the agent's saying. There are great agents out there that will be making sure that owners' properties are compliant, because reputationally it's good for everybody to make sure. And I believe that that's what there's an agency accreditation scheme at Visit England. So if it's a Visit England accredited agency, they would have to be checking that those properties are met with compliance. So there are great places to advertise your product, as well as some perhaps less great, if I'm allowed to say that. Okay, coming to GDPR, there's a question about, can we send Christmas cards to our guests? Beth?
That kind of depends. If you have, if they have booked with you and you have collected their data as a result of their booking, then there is something called an ongoing interest. They all have to have tick boxes. They'll have to opt in now. You can't necessarily just contact people who have sent you an inquiry, but if they have stayed with you, then yes, you can send them a Christmas card. If they have only inquired and happen to have left their address, then unless they've specifically opted in, don't send them a Christmas card.
Thank you. Anybody else want to add anything on GDPR? Okay, moving on.
Alistair, should we mention about the detectors?
The
noise and mobile phone detectors.
Yes, crack on. Good one. You cover that, please.
Okay, there is a lot of advertising going on lately about monitors for guests on your property. So these monitors will do things such as monitor noise levels, monitor movement, and monitor the number of mobile phone signals that are within your premises, so that you can know how many people are there and how much noise that they're making. Now, there are questions about where these interact with GDPR and what the legality of them is. I've been talking to a lawyer recently, and they are legal because they are not actually recording and storing any personal data. So they're being designed to get round GDPR regulation. The only thing that you need to do, there's two things you need to do. One is you need to disclose to to visitors that they will be monitored, okay, because visitors, people staying in your property, have a right to privacy, and part of that right to privacy is that you need to disclose to them if there is anything where you are monitoring them in any way. Okay, so you must say, we have this equipment installed in the property. That way the person has the ability to say, I'm not happy with that, therefore I'm not booking with you, or I'm fine with that, I'll go ahead with the booking. There is also a degree of proportionality to this in terms of what you're monitoring for. How your monitoring system has to be proportional to the problem that it's trying to solve. For example, if you're monitoring because of you don't want people having parties on your premises, then putting a noise detection device in your lounge would be proportionate to that problem. Putting a noise detection device in their bedroom is probably not proportionate to the problem that you're trying to solve, and therefore they could complain in terms of their right to privacy.
Thank you. And I'm sure a lot of remote owners are looking at these tools to help them manage their properties. I'm going to duck straight back to fire. And
just one quick, Alistair. I don't know if it's been mentioned because my connection dropped off, but if you have any kind of CCTV, including doorbell CCTV, you need to register with the ITO.
Yeah, we're going to cover CCTV just in a second. It's come in. So the next question I want to get to is seasonal glamping site, 2 yurts, small gas stove in each one. They can't get anybody to come and do any kind of test make sure they're doing it right. But I'm guessing that, a fire risk assessment, but Kurt, if I say anything wrong in answering this question, or Ross, a fire risk assessment is proportionate to the risk that is incumbent upon the business. So if you were writing a fire risk assessment for a 200-story hotel in Shanghai with multiple lifts and goodness knows what else, that would be a very, 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 very large document. 2 yurts is quite a short document because the risk is quite small. Okay, you've got easy access to the exit. So if you are providing a fire extinguisher, if you are having carbon monoxide and fire detectors and a fire blanket, and you explain to the guests what to do, that is probably a proportionate risk assessment for the size of your business. And you can't, if you've got wood burning stoves in there, which is what you've got, a gas stove, that gas stove does need to be gas tested every 364 days, no exceptions. That's the law. Okay, that's not a guidance. So, if you've got your fire kit being tested, if you've got the fire guy who came and provided you with a fire extinguisher telling you the best place to put the fire blanket, if you've got clear instructions to your guests what to do in the event of fire, which is presumably leave through the door, which is not very far from the bed or anywhere else, you might have to provide an axe so they can hack through one side of the yurt if they can't get out the door. But really, proportionate to the risk is what we keep saying to people. When you now can move away from a yurt, though, to holiday cottages, getting lots of questions with people being told by various agencies, whatever, that the fire alarms need to be linked. Well, the law isn't clear on that, but let's now move to the risk assessment. You've got a large kitchen dining room downstairs and you've got 8 or 9 bedrooms upstairs, for example, and it's not linked and there's a fire in the kitchen. How do those people in the bedroom know there's going to be a fire? So when you're actually doing the risk assessment, you'd have to work out how they would be notified of the fire. So if you don't want to retrofit wiring, perhaps a Bluetooth system might answer that risk. So the risk assessment is examine what the risk is and what steps you're taking to mitigate and reduce that risk. So that answers quite a lot of those. Lots of EV charging questions. PASC published last week an EV charging paper which covers this in some detail. It's available on the website, but essentially it really isn't good practice putting a 3-pin plug through a window on a damp day outside and plugging a car in. Insurance companies haven't quite caught up on this, so they're not very specific, most of them at the moment. I can assure you they will be when things start to go wrong, and they will be much more clamping down on this. So again, read the paper and it will tell you if you've got EV charging or you're thinking about it, how you can again reduce the risk and make sure that you're doing safe charging, which is, the person they're protecting there is you and your business as much as the consumer. So coming back to CCTV, ICO, Beth, do you want to just say a bit about CCTV and ICO?
Yeah, if you are using CCTV anywhere on your premises, then A, you need to have signage, and B, you need to register with the Information Commissioner's Office. And you are likely to have to register with the Information Commissioner's Office anyway if you are handling guest data. So it's worth having a look at their website, but definitely for CCTV, you need to register with the ICA.
Right, this is an absolutely a full disclosure thing, just like Kurt was talking about the noise monitors. We do have some people who've been in contact with PASC over the last 6 months who have had CCTV over hot tubs, believe it or not, without actually telling the guests. And then the guests have misbehaved and they've said, we know you misbehaved because we got it on film. And instead of that being used as evidence to deal with the guest's misbehavior, those guests are taking the owner to court for invasion of privacy and goodness knows what else. So, CCTV, we've done a paper on CCTV. It's free on the website. We've done a paper on whether you need to pay the ICO on the website. Basically, if you collect and handle any guest data and use it in any way, so the Christmas card list, you need to register with the ICO. So those papers are available. How to do CCTV, how to do the full assessment that you have to do for CCTV, that is also on the PASC website. So if you have CCTV, you must disclose it, and there are some forms you need to fill in when you're registering. Okay, so that's that. In reality, Ross, in reality, how many prosecutions do we actually hear of on this kind of stuff?
No, from my side, I mean, Kurt, back me up if you think differently. But no, you know, we're not seeing them come through. But of course, every now and again, when you see a local newspaper picking up on a non-compliance story, you know, that can be very damaging, negative publicity. So yeah, there's a balance. Like everything, there's a balance to be struck here, isn't there? And I think you're right to say, you know, there are some grey areas. You know, we're trying to be as black and white as we can, and through the Pink Book, we try and be as clear and as black and white as we can. But inevitably, the area that we're dealing with on legislation, there are purposely grey areas put in to certain pieces of legislation, it would seem. So we will help you pick through the very best you can to minimise risk around negative PR.
If you
if I can just add to that, Ross is absolutely right. You don't get very many complaints, but the ones that you do are certainly eye-openers.
Yeah.
And if we go back to what I was saying about the noise monitors, yeah, it's disclosure and it's proportionality. It's you have to, at the end of the day, be able to stand up and say, this was the risk I was trying to mitigate against, and it was reasonable for me to put a CCTV camera in that position to mitigate that problem. Now, if you've got someone who's comes in and starts nicking things from properties, it's reasonable to put a camera at the entranceway so you can monitor people going in and out. It's not reasonable to put a CCTV camera in the person's bedroom because that's where the stuff was being nicked from. Yeah, it's common sense and proportionality.
Okay. There's a chap I know who works for one of the very, very large self-catering agencies, and I would guess they do probably something like 1 million guest nights a year, something like that. And he would answer that by saying, the risk is very, very small, but at least 12 people die in one of their cottages every year. And most of those people die by falling down the stairs, possibly and probably due to imbibing of some substance or another. So there is real risk. There is real risk. You really don't want to be one of those 1 in a million and find out that you haven't mitigated the risk by writing a risk assessment, by having the insurance in place, in which case you just pass it to your insurer to deal with and move on. Okay, all of you have properties that are probably worth enough for a guest to go after you personally, so make sure you don't put yourself in that position. Okay, we're coming towards the last couple of minutes. I've got a question's coming from Tracy, and it's about refusing bookings. Under the Equality Act, which brought all of the discrimination acts together under one act, you cannot refuse a booking for any reason for anybody over 18, except you can. There is a way that you can do it if you know that that person, specifically that person, has been before and has caused damage to your property, and you have documented that. And this can be contemporaneous evidence, but you have documented that. Much better, of course, if you've sent them emails telling them that they've damaged the property. If they wish to book again, you can say, no, I'm not going to allow you to book because last time you came, you did some damage. And that would stand up, and the judge in a case would say, you have a legitimate reason for refusing that booking. What you can't really do is pick and choose and say, don't like the sound of you, but I like the sound of you. You can't do that. But you can, if you have reasonable grounds, you can refuse a booking. So you'd be hard pushed to say, I don't take stag nights, unless you've had stag nights before that caused you a problem. You can't assume that the customer is going to behave. You need some evidence. So Ross, I can see you want to add to that, and I'm sure Kurt will. But in essence, if you have proof that a previous customer has misbehaved, you are perfectly entitled to refuse their booking.
Yeah, I would say the thing to be aware of there is the Equality Act, because the Equality Act names a number of what they call protected characteristics. Age is a protected characteristic, sex is a protected characteristic. So the stag do thing, you would have to be very careful on refusing the booking and evidence that it's not related to it being a group of males, because as I say, that's a protected characteristic. I see the question that was asked here mentions that the guests have another protected characteristic, which is disability. So in refusing a booking, you would have to be very, very clear and transparent that the reason and the rationale for the refusal is not in any way related to their protected characteristics. So it's what I would say is a complicating factor in the example that the person's given here.
However, if they want to come and stay and they are a wheelchair user and you don't have wheelchair facilities, then I would suggest it wouldn't be unreasonable to say my accommodation is not suitable.
Very, very dangerous ground. You need the individual to come to their own conclusion that your property is not suitable. You want to be very careful in no way writing anything that is suggestive of not taking their booking because of their access requirements.
If my house has only got upstairs bedrooms and somebody writes and says, I'm a wheelchair user and I'm booking your house for a week, there must be a question mark over how suitable it would be.
Yeah, and you would give them your accessibility guide that would have a detailed description of your accessibility, and you would draw to their attention those kind of limitations in the accessibility. But then what you need is for them to come to the conclusion, really.
But if they say, I still want to go ahead, then you can't stop them.
No, because they may not have told you that they're a part-time wheelchair user. So they may have described themselves to you as a wheelchair user. You then think they're a full-time wheelchair user and they can't access the room. They see the information, they say, no, I'm absolutely fine with the accessibility of the property. I want to go ahead and book. And they hop out of the wheelchair to go up the stairs because they're a part-time wheelchair user.
Then get it in writing.
If I could come in on this, one of the ones that's rearing its head is you've got to be careful in terms of discrimination, that any rules that you come up with don't disproportionately affect someone with a protected characteristic. And a very kind of good example at the moment is saying that I will only accept people on my property who've been double vaccinated. And you may think that that is perfectly reasonable. However, because young people are disproportionately unvaccinated compared to elderly people, you can get caught up in equality laws.
Okay.
Because you're disproportionately affecting young people and preventing them from staying on your property.
How does that then, there are places that say they're adults only. How would that impact on people who have specific characteristics of their property? No children allowed.
There are a few properties that you can get which will cater for kind of elderly people only, and that is acceptable under the equality legislation because it is providing a greater benefit to them rather than a disbenefit for other people. So you can have, for example, you can have, you still have a pensioner's discount. That would be acceptable because it is providing an additional benefit to them rather than a disbenefit to other people.
And can you say, I have a water mill, therefore no children under 12?
Well, you can say no under 12 because the age discrimination only comes in at 18.
Okay, I'm just going to try and rattle through some questions that have come in on track and trace. Details, do we still need to record the data post the 19th of July? It is won't be mandatory to display a QR code or gather the guest data after the 19th of July. It'll be guidance only, as we've covered lots of things through here, but it won't be mandatory to do that. I'm not sure about what that question means. do we continue with COVID practices after Monday? Someone missed that. Yeah, we think you should. It's guidance only and highly recommended, but we think that absolutely the pandemic is still out there. We should absolutely be continuing to follow the protocols, but it goes from guidance on the 19th. It goes from law to guidance on the 19th. I don't know what that question is, sorry. Just trying to make sure we covered as many as we can. There's a question here about not sure why insurance and electric vehicle charges mentioned together. Well, if a guest of yours brings a not very well made cable with a not very well attached 3-pin plug and sticks it through the window and plugs it into your non-compliant socket, and his car catches fire, you know, you need to read the EV paper and protect yourself against these things happening. You should have in your terms and conditions that you don't want people to do that. You should absolutely be making it clear that that is a risk to both their vehicle and your premises. So it is a real insurance risk if people blindly just connect up without these being proper tested sockets, and it's all covered in the paper. Just trying to see if anything more has just come in at the end. I think people asking about guidance notes on games rooms and things after the 19th of July. I mean, there is no legal requirement to socially distance in things like games rooms and swimming pools. And so if you've been running rotors, you don't have to. We will continue to run our rotor. We've always run a rotor on the swimming pool here, so we give private swimming, but you wouldn't have to continue to do that from the 19th of July in England, but you may wish to continue, as we talked about earlier, for the customer confidence and that kind of thing. So I'm thinking we're pretty much there. I'm going to ask a favor, because I can't grab all these questions. If we haven't answered any questions, by all means send them to chair@pascuk.co.uk, and I will try and get to them over the next few days. If you've recommended on here, Victoria, you've recommended your PAT testing person, please send that to me and I will put them in the trade directory on the new website, and I'll put our one on there so we can start to try and build up a directory of people who do give good service and good price PAT testing and electrical testing in there. So I think I'm going to take the opportunity. We've run over by 7 minutes. Thank you to all of you who signed in for the webinar. I hope you found it useful. We've had some good comments coming back. I would personally, of course, like to thank, first of all, Beth, and then Ross and Kurt for being the panelists today and bringing their expertise. And I hope very much that you found it all useful and that you will join us in the future for the summer webinar program. So with that, I'm going to say thank you to everybody. Thank you very much indeed, and sign off. Thank you.
Thanks. Bye.